Welcome to this in-depth video on marriage and the 10-year immigration bar. First, we will set realistic expectations about what marriage does and does not fix in U.S. immigration law, especially when there has been a long overstay. Next, we will break down the 10-year bar, the waiver requirement, the timeline, and practical strategies. Finally, we will finish with key takeaways and suggested next steps. Here is our roadmap. First, we will address the myth that marriage clears immigration problems. Then, we will explain the legal 10-year bar and how and when it is triggered. After that, we will unpack the I-601 waiver, including the extreme hardship standard. Next, we will lay out realistic timelines. Then, we will discuss persuasive hardship evidence and strategic alternatives, such as relocation. Finally, we will test your knowledge with a couple of quick quizzes before wrapping up with key takeaways. To begin, let's get clear on the core misconception. Marriage to a U.S. citizen does not automatically forgive prior immigration violations, including long overstays. This distinction is crucial to avoid costly mistakes and false timelines. With that foundation, let's address a necessary disclaimer before we dive into the legal mechanics. Before we proceed, please note that this video is for educational purposes only and is not legal advice. Immigration outcomes depend on specific facts, and rules change. Therefore, you must consult a qualified immigration attorney to evaluate your situation and determine the best strategy. Now, with the ground rules set, let's examine the myths and the actual law. Let's start by contrasting myth and reality. The myth is that marriage instantly forgives an overstay and leads to quick approval. In reality, if someone overstayed for a year or more, leaving the U.S. will trigger a 10-year bar on returning. Another myth is that obtaining a tourist or marriage visa will be straightforward after departure. In fact, the 10-year bar creates inadmissibility, and a demanding waiver process is often required. With those myths dispelled, let's unpack the 10-year bar itself. Here are the fundamentals of the 10-year bar. If a person overstays for 1 year or more and then departs the United States, that departure triggers a 10-year period of inadmissibility. The law views multi-year overstays as serious violations, not trivial errors. As a result, the person cannot simply apply for a tourist visa or a marriage visa as a workaround. Given this framework, our next step is to explore the waiver pathway that may allow reentry despite the bar. This flowchart illustrates two paths. If there was no prolonged overstay, the couple typically follows the standard spousal process: filing the I-130 petition, completing National Visa Center processing, attending a consular interview, and entering the United States. However, if there was an overstay of more than 1 year followed by departure, the 10-year bar is triggered. In that case, the person must pursue an immigrant spousal visa and an I-601 waiver. The waiver hinges on proving extreme hardship to the U.S. citizen spouse. After the consular interview, the waiver is adjudicated. If approved, the visa can be issued, and the person may enter the U.S. If denied, they may have to wait out the remainder of the 10-year bar or revisit their strategy with legal counsel. Next, let's break down the waiver requirement itself. Here is a practical action plan. First, confirm that your case requires the immigrant spousal visa with an I-601 waiver. Second, engage a certified immigration attorney as early as possible. Third, begin assembling evidence that shows extreme hardship to the U.S. citizen spouse, understanding that ordinary emotional distress or routine financial inconvenience typically does not suffice. Fourth, file the I-130 while preparing your National Visa Center package and hardship documentation in parallel. Fifth, attend the consular interview and pursue the I-601 waiver as directed. Sixth, respond promptly to any requests for additional evidence. Finally, if the waiver is denied, consult counsel to evaluate appeal options or determine whether waiting out the remainder of the 10-year bar is the only viable path. Next, let's get specific about what counts as persuasive hardship evidence. This table outlines common categories of extreme hardship evidence. Medical evidence may include chronic illness documentation, specialist letters, and proof of limited access to treatment if separated or relocated. Financial evidence can cover joint obligations like mortgages, employer affidavits, and proof of substantial income loss. Psychological evidence may involve professional evaluations and records indicating impacts beyond normal sadness. Caregiving evidence demonstrates dependence by elderly or disabled relatives or children with specialized educational plans. Safety and country conditions evidence relies on reliable reports showing crime, instability, or poor healthcare access abroad. Finally, community and integration evidence establishes how the U.S. citizen spouse is rooted through employment, licensure, or obligations such as military service. Next, we will set realistic expectations about timing. Timelines are often longer than people expect. While some hope for a 3-year resolution, cases involving the 10-year bar and an I-601 waiver frequently span 5 to 7 years. The stages typically include I-130 filing and evidence gathering, National Visa Center processing, a consular interview, and, crucially, I-601 waiver adjudication, which can add substantial time. If the waiver is denied, the foreign national may have to wait the remainder of the 10-year bar before attempting reentry. Next, let's compare optimistic expectations to realistic ones. On the left are optimistic expectations such as rapid approvals, minimal evidence, quick travel, and low legal risk. On the right is the more realistic picture for waiver cases: a multi-year process, the need for an extensive hardship evidentiary package, prolonged waits with uncertainty, and the importance of strategic legal guidance throughout. With these contrasts in mind, let's test your understanding with a quick quiz. Quiz time. What actually triggers the 10-year bar for someone who overstayed more than 1 year? Is it the marriage ceremony itself, filing the I-130, leaving the United States after a 1+ year overstay, or attending the consular interview? You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is leaving the United States after a 1+ year overstay. That departure triggers the 10-year period of inadmissibility. Now that we have established the trigger, let's test your understanding of the waiver requirement. Second quiz. To win an I-601 waiver in this context, what must be proven? Is it that the foreign spouse will be sad if abroad, extreme hardship to the U.S. citizen spouse? That the couple plans to have children? Or that the foreign spouse has a U.S. job offer? You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is extreme hardship to the U.S. citizen spouse. Normal separation or typical financial inconvenience usually does not meet the standard. Next, let's consider strategic alternatives for couples facing a long waiver process. Couples should evaluate strategic alternatives. Relocation is one option. The U.S. citizen may move abroad to live together during the process, which removes the immediate U.S. entry hurdle, but introduces new challenges such as licensure portability, healthcare access, and schooling. If relocation is not feasible, create a robust long-distance plan covering communication, visits, budgeting, and caregiving responsibilities. Remember to prioritize mental health and community support. Schedule regular check-ins with counsel to adapt your strategy as policies and processing times change. Next, we will cement the most important takeaways. These are the key points. First, marriage does not erase a long overstay. Departure after 1 year or more triggers a 10-year bar. Second, the I-601 waiver is often essential and requires strong, attorney-guided evidence. Third, timelines of 5 to 7 years are common for bar and waiver cases. Fourth, success depends on a thorough extreme hardship record. Finally, consider relocation or a well-structured long-distance plan while waiting. To close, let's summarize and provide a clear call to action. In summary, set expectations early and avoid the trap of believing marriage fixes everything. If the 10-year bar applies, prepare for a rigorous I-601 strategy and assemble persuasive extreme hardship evidence. Recognize that timeframes can be long, so budget for both financial and emotional endurance. Professional legal guidance is crucial at every stage. Finally, let's end with a quick creative nudge to support the channel and keep the conversation going. Thank you for watching. If this video helped you understand the realities of marriage and the 10-year immigration bar, please like, share, and subscribe for more clear, practical guides. We would love to hear your questions and experiences in the comments. Your input helps others navigate this difficult process. See you in the next video.